Hey guys, good morning. This is attorney Sivonnia the protector of athletes, also the creator and founder and principal attorney of the SL DeBarros law firm, where we represent 6 and 7 figure business owners and athletes in business and individuals in employment and labor disputes. So I have 3 quick tips that I want to share with you all. For some reason today, this really just fell on my heart to share, and I think it's important that I provide this information to you guys. So we have a lot of individuals who have created businesses during the pandemic, or folks who really have had the ability to soar well beyond what they thought that they would have been able to do during the pandemic. And so with that always brings about the question of contracts. What about those contracts? So I had the distinct pleasure of doing a contract review slash editing for a very popular New York Best Time seller. I mean, it was amazing, right? But what I also realized, even people who are absolutely, just so brilliant, there are some things that they just don't know, right? And so if a New York Times bestseller doesn't know some of the things that was literally in this contract that may not have played in their favor, you may not also know these things. So there are some things that I want to just provide to you as a tip, so that when you are reviewing your contracts, these are at least 3 things that you're thinking about. Now, I do want to put a disclaimer in here, because this does not mean that just because I talk about these small little tips, that this is everything that you need to think about. Absolutely not. I will definitely buttress this with make sure that you do have counsel. It's always best course of action to hire counsel to review your contracts for you, to edit those contracts, negotiate those contracts on your behalf, especially if you do not have any legal training. Okay, so with that said, first things first, read the contract. Read the contract. I always ask potential clients, have you read the document? Do you know what it purportedly states, right? What exactly are you receiving in the contract? So for example, with this New York Best Time seller, this contract was for this individual and another popular business brand to do some business together, but instead this would be more so like providing advisory services for percentage of equity. But the contract didn't really read that way. Okay, so know what you're supposed to receive. Know what the timeline is supposed to be on in terms of what you're supposed to receive. And the only way you'll know that is if you actually read the contract. So one thing that you need to keep in mind too is when you initially talk about contracts or some type of deal with someone in an oral type of fashion, and you go and you sign on a hard copy, the dotted line, so whether it's electronically or in person, physically with a signature, what you've done now is you have housed all of your understanding and beliefs into that contract. And so some people don't realize that you cannot amend a written contract based on oral statements. Okay. So that's why it's important to read it, because what you think you may be getting based on the oral arrangement that you made may not be what is stated in the written terms. And so those written terms will be considered as the full understanding of both of the parties at the time of signing the contract. Now, there are things and defenses and all kind of stuff that you can possibly raise to get out of that, but why go through the trouble when you can, just hit it head on in the first instance, and make sure you read the contract and understand exactly what it is that you're supposed to receive. Now, the second tip is sometimes contracts will refer or incorporate other documents. With this particular example that I told you about, there were 2 separate contracts that were referred to and supposedly incorporated into the document. However, The client had never seen these documents, didn't know what these documents were. So they were unable to truly and fully understand the breadth, the full scope of what their obligations was, and exactly how they would be positioned in this business. So those two documents that were referred or mentioned in the contract were an advisory contract and an operating agreement. And so one of my questions was, okay, well, if you're going to be an advisor, are you receiving equity as payment of an advisor? Are you going to be an officer of the company also, which means that there's going to be additional responsibilities that you may have? Would you have voting rights? There are so many questions that could come up from this. So make sure you have the other documents that the individuals state, refer, or are incorporated into the contract, your master contract technically, that you're sitting down and reviewing. Okay, so that is tip number 2. Tip number 3 is about taxes. I'm not a tax professional. I'm not a tax lawyer. I'm not going to give you any advice on tax, but I do want to just encourage you to hire a CPA, an accountant, because sometimes, depending on the type of contract that you have, it may require you to understand certain tax penalties or exemptions, or what your obligations would be in terms of filing your own taxes. So with this particular example, there was tax provisions because the agreement was more so about equity or stock payments, right? And so there are certain ways that the SEC may treat individuals who are selling stock or membership interests. Now, it's so different because stock is for corporations, membership interests are for LLCs, companies. And technically they're treated completely different, but there are certain rules by the SEC where there may be a certain circumstance where a member of an LLC who sells their membership interest may not be able to find themselves in an exemption from the SEC where they would have to report the sale of this equity or the transferring of this equity. So you want to have possibly a secure transaction attorney on board, especially if you are in something that is now a lot more intuitive and convoluted, and bringing to those issues of secure transactions and taxes. You may want to have that person on board to review that particular piece of the agreement, but you also want to have a tax professional on board who can truly speak to what your obligations would be with filing whatever necessary papers to ensure that you are not running afoul any tax laws. So to recap, 3 tips: read your contract, understand what you're getting. 2, ask to review the additional documents if there are documents that are purportedly referred to, incorporated, or referenced in your master agreement, the only thing that you think you're signing. And 3, seek advice from other professionals like a tax professional or a secure transaction attorney. Okay, guys, this is Sivonnia DeBarros. I definitely hope that this quick 3 tips to use in your contract review has been helpful. If you have any questions, make sure that you email us at sdebarros@sldebarros.com. Visit our website at sldebarros.com. Make sure that you sign up for our free course, What About Those Contracts, so that you can stay educated and make sure that you are protecting your interests. Again, Sivonnia DeBarros, protector of athletes. Until next time, check you later.